Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 338 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all compliance-related services. I'm pleased to announce a new service offering, the Compliance Alliance, which provides you and your sales team an in-depth and insight into the recently released Department of Justice prescription to operationalize your compliance program, sponsorship of my 1 month Do a Better Compliance Program podcast series, and finally, training with your sales team to fine-tune your message for every Chief Compliance Officer. For more information, please contact me at tfox@tfoxlaw.com. Today I have with me Steven Durham. Steven is a partner at Labaton Sucharow in Washington, D.C. This is a firm with an incredibly vibrant whistleblower practice at the SEC. Steven has joined the firm, and we talk about the whistleblower practice at the firm, Steven's role, how it was created by Jordan Thomas and his former role at the SEC. We talk about the SEC Whistleblower, some of the incredible numbers that have come out even this year around whistleblower remedies and rewards. We discuss the firm's process for the evaluation of cases, how long it takes, what he requires, what he prefers in terms of documentation. We have a very interesting discussion on how the SEC Whistleblower Office facilitates the SEC's mission to protect investors and how firms like Labaton assist the SEC in that regard. We also discuss how whistleblowing benefits society and corporate America going forward. Finally, we end up with some of Steven's thoughts about where the SEC Whistleblower Program is going under the Trump administration. It's a fascinating episode. It comes in at just around 20 minutes. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox again, back for another episode of the FCPA Compliance Report. Today, you are in for a real treat as I have Steven Durham. Steven is a partner at Labaton Sucharow. I hope I got that right. A law firm, and he has a specialty practice in whistleblowers. Steven came from the U.S. Attorney's Office and then went through the wars at Weatherford, and now he has joined Labaton. So, Steven, with that somewhat long-winded introduction, welcome and thanks for taking the time to visit with me today.
Good morning, Tom. It's a pleasure to be here.
So, Steven, I was wondering if you might be able to describe the whistleblower practice at Labaton and what is your role in that?
You bet. Be happy to. I joined Labaton Sucharow last month, and I joined from, I worked at Weatherford International in the compliance group there. So Labaton Sucharow has a whistleblower representation practice. And it was started by Jordan Thomas in 2011. And Jordan was one of the principal architects of whistleblower rules that were written when he was at the SEC. And he saw the future, and he joined Labaton Sucharow and developed practice. And now I've joined along with two other partners who are former SEC people who have a great deal of experience. A very exciting time to be in the practice. The SEC Whistleblower Program is just, I think, now gaining its stride and getting really up and running, much better known. And as I said, it's a very exciting time to represent clients here.
So we last September, I believe, was the month that the SEC Whistleblower Program crashed through the $100 million amount or level amount of bounties paid to whistleblowers. So I certainly agree with you that it is a very exciting time to be in it. I was wondering if you could, for my listeners who might not be aware of the SEC whistleblower process, describe that process and how you would help a client work through or walk through that process.
So what happens is at the SEC, there's a series of rules that determine whether a whistleblower is eligible for a bounty. And so information comes in, and then we develop relationships with clients. So we're very careful about the matters that we take in. So we vet our matters very carefully. So we talk to clients, and we get as much information as we can. And we have a team So we have a team of people, not just the partners who work in the group, but we also have professionals, former FBI people, accountants, a former controller, and we're very careful about the way we look at matters to make sure that they are good matters, that they're matters that allege a securities violation, and that they're matters that ultimately we believe will pay the appropriate bounty to the whistleblower. So we take that information in, and then we put a case together. We put the case together for the SEC, and we submit through the SEC's site a TCR form. And then we make sure that we put as much detail in that submission as we can to assist the SEC in doing its work and to push the case as far down the road as we can. Of course, there are no promises or guarantees. No one has a crystal ball. But our goal is for the SEC to take the matter, to use its authority and its power to make out a securities violation. And then at the end of that process, and this process takes several years typically, but at the end of the process, Tom, we'll come back and we'll make a petition in the form of a whistleblower application form. We'll make a petition for an award. And a whistleblower who's successful is entitled to between 10 and 30% of the total enforcement action. And we'll make an argument as to why our client is entitled to 30% of the enforcement action.
Steven, you mentioned that not only this is an exciting time to have this type of practice, but also that you really felt like the SEC Whistleblower Office was really hitting its stride. Could you explain how the Whistleblower Office and indeed the Whistleblower Program facilitates the SEC's mission to protect investors, and how firms like yourself, or Labaton rather, can assist the SEC in that regard?
Yes, absolutely. So the program was devised and it was created out of Dodd-Frank, which was the Dodd-Frank Wall Street Reform and Consumer Financial Protection Act in 2010. And the goal was, of course, Dodd-Frank was created out of the financial crisis and scandals like Madoff and other financial scandals that occurred on Wall Street and elsewhere. So the goal of the program was to empower individuals so that individuals who had important information could come forward, that they could feel comfortable in coming forward, that they could, if they so choose, they could report anonymously, and they could share information that is very valuable to the SEC in carrying out its important work. So, you know, the program is trying to create an atmosphere where people feel comfortable. There's a very strong anti-retaliation provision built into the whistleblower program and into the legislation. And that has been used as a standalone action, even without an enforcement by the SEC. So, you know, the goal has been to empower people. The goal has been to provide the SEC with access to important information that it would not otherwise have, or have very late in the game after catastrophic consequences. And it has worked. It has been extremely successful. And of course, the program also financially incentivizes people because a lot of times, you know, we ask people stick their neck out, literally and figuratively, in the sense of they stand up, they give information, and because they give information, they may jeopardize their career or their reputation. So the program financially incentivizes people to stand up and do the right thing, and it has been tremendously successful. I think, as you mentioned, there have been 44 successful claims that have resulted in over $150 million in whistleblower payouts. But as I said, the program is just really now starting to hit its stride, and the reason is because these cases take some time to get through the system. They usually take between 4 or 5 years to get from soup to nuts. So now we're really starting to hit some larger awards, and I expect within the next 12 months you'll see some of the largest awards in the history of the program itself. But there are a number of cases that are in the pipeline. There are a number of clients that we represent whose matters are in the pipeline. And of course, as the program becomes more well known, and as we educate more more people we believe will come forward and do the right thing.
So you said a couple of things in there I'd like to follow up on, Stephen. The first one was the $150 million in bounties paid. My figure of $100 million was from last September. So in the first 5 years, it took 5 years to get to $100 million, and in, I guess, 8 or 9 months, we've gotten another $50 million. So you're absolutely right. This program has really taken off. The other thing is that you mentioned, and I'd really like to explore how your law firm really works to vet the cases so that if you present them to the commission, you at least internally, or the firm has internally, feels like there's a good chance that the commission would look at it and it would benefit the commission to move forward. So you talked about some of the talent and experts you have on. How would you think through or work through a potential claim that's presented to you or the firm?
We go through a process, and so we have information, Tom, that comes in from all kinds of different sources. A lot of our clients are corporate executives who are in a position to see certain things, and maybe they don't have the whole picture, but they have very important parts of it. We have some of our clients who are outside of the system entirely, who are analysts, or they look at 10Ks, or they look at other reports, and they see things that just don't quite add up. And they look at it and they're able to kind of put some of the pieces together. What we do, and we encourage people when we talk to people, we try to get as much information as we can. And some of that information is going to come from clients themselves. In fact, a great deal of it oftentimes comes directly from the client because they're in a position to see things. They're in a position to hear things. They may have access to documents, legal access. We don't ask clients to do things that are illegal. But they may have access legally to email or documents as part of what they do. So we're always looking for as much corroboration as we can. But as far as what you referenced is, we do have a team. So I'll give you an example here. We have 4 partners in our group now. So collectively, we have over 60 years of SEC experience in the enforcement division, including my partner, Tim Warren, who was in the Chicago SEC office as acting regional director, and my partner, Bob Wilson, who was in the SEC in Washington and various management positions. Of course, we have Jordan, who's the chair of the practice and who wrote the rules. But so we have a lot of experience, but behind that experience, and then I spent 20 years myself at the Department of Justice. But behind that experience, we also have a team that's fully dedicated to serving client interests. And on the team, we have former FBI agents who were financial fraud investigators. We have a former controller of a company. We also have a team of accountants. And so we put a lot of time and effort into the evaluation of the case to make sure, as much as we can, we don't have a crystal ball, obviously, but as much as we can to make sure that it alleges a securities violation, that it's a serious securities violation, that it's provable, that it's within the statute of limitations. So we go down the list and make sure that we can write it up and that we can provide information that's necessary. So because it's a team effort, clients don't pay any more for the team than they would for any one individual on the team. We want to make sure that the SEC is getting absolutely the best, most fully developed information that they can get. So when they get it, they can use their resources, which are limited. So they can use their resources in the most efficient manner and identify securities violation and hold people accountable.
And that really brings me to another point, Stephen, which is that I really see not only the Whistleblower Office, but frankly, the activities of you and your law firm as benefiting not only SEC, but American securities law going forward, because through this rigorous vetting process, you're presenting cases to the SEC that at least the law firm feels like could potentially represent a securities law violation. And then, of course, you're letting the SEC do their job as regulators and enforcers going forward. Do you see that as really part of a continuum a philosophical continuum that I see, or is it something different?
No, I think it is, Tom. I think that, especially in the wake of, back in the early 2000s, I mean, this has been going on for quite some time, but in the early 2000s, you had, Enron, and, then you had Sarbanes-Oxley, and then, you have matters like Madoff and the financial collapse or meltdown in 2008. Then you have Dodd-Frank. But I think the broader discussion here is trying to, make sure that everybody is on a level playing field. When investors go out and invest money, or when companies try to compete, they want to have some confidence that they're competing on a level playing field. And you may not win the game. You may not win every game you play. And of course, that's part of the cost of playing the game itself. But you want to make sure that it's fair, and you want to make sure the officials are empowered, the regulators are empowered, and you want to make sure that people who have the courage to say, let's see something. And these are our clients. This is what our clients come to. They think, well, this is wrong. I mean, this is just not right. This is not fair. It's not proper. There are people being hurt by it. There are investors being hurt by it. There are competitors being hurt by it. And I need to do something about it. So I think part of the broader discussion you've identified is one in which there is a recognition that people can and should speak up. And those people should not be thrown under the bus or retaliated against or somehow discouraged or ostracized or blackballed, that they should be empowered and that they should be rewarded, frankly, at the end of the process if they do the right thing and it's valuable information. And this is the whole impetus behind the Office of the Whistleblower, which has been extremely successful. It's received bipartisan support. And I do expect that going forward, it'll continue to be a very successful program.
And so that really leads me into a question I'm almost hesitant to ask, but I have to ask anyway, which is, do you see anything changing under the Trump administration for the Whistleblower Office, either from the executive or legislative changes?
Let me just reference my own experience as a federal prosecutor. And I was at the U.S. Attorney's Office in Washington, D.C. for 20 years. I was chief of the Fraud and Public Corruption section there for a period. So I was there 20 years, and administrations changed. I started when President George H.W. Bush was president, and I left when President Obama was in office. And so I saw a number of different administration changes. And the core work of the regulators, whether it's the Justice Department or the SEC or whoever, the core work doesn't change, because it's not really an issue of, is it a Democratic issue or is it a Republican issue? It's a moral issue. It's a legal issue. It's an issue of right and wrong. So to answer your question, I really don't see vast changes. Now, of course, there's fine tuning that goes on around the edges. That's true with every program. There's tweaking and adaptation, and I think you'll see that. But as far as sea changes to the program, I think it highly unlikely. And I say that because, I look at the people that have been nominated in key positions at the commission. Chairman Clayton, who's obviously very qualified and extremely capable, and the people that have been nominated and placed in the enforcement division, Steve Paikin and Stephanie Paikin, are very experienced people, very well-versed, and very committed to protecting investor rights and keeping the marketplace safe and fair. So the short answer, made long, is I do not see large changes.
So I'd like to ask to draw upon your experience from your DOJ days. And really, I was wondering if you could tell the audience what it means for a prosecutor, or back when you were with the DOJ, or a regulator, to have someone, an insider such as a whistleblower. What does that extra does that provide to a prosecutor to allow you to do your job?
The short answer really is the quality of the information that somebody's providing. And many times, as a prosecutor, we would look for the best, most reliable evidence possible. And that evidence is going to come from people who typically are on the inside. If I'm reading about it in the newspaper, 3 days after the fact, or, if I've heard it from somebody as I'm walking down the street, well, it's not that it's useless information, because sometimes it leads to things, but it's the insiders, the people who are there, the people who actually see things and know things. So as a prosecutor, like a good reporter, you go to the source. I mean, let's go to the source. And the source a lot of times were people who were on the inside. Sometimes people who were on the inside were compromised in the sense that they were participants themselves. And this is an ongoing discussion, and this is probably one of the fine-tuning areas of the program. So what do you do about somebody who may have committed crimes themselves? Well, they're in a position to know things because they participated. Now, of course, in the office of the whistleblower, the rules are quite clear. If you're convicted of an offense, you are not eligible for an award, and nor should you really be. But there's a debate that centers around, well, what if you're a participant and you're not convicted and you're kind of on the edges? So should you be eligible for an award there? And that's a discussion that I think is going to continue to occur as we go down the road. But as a prosecutor, you're always looking for somebody who had the best information.
Stephen, one of the things we've seen in some whistleblower awards is anonymous whistleblowers. And I think that the conclusion I would draw is that many, or at least some whistleblowers, really need or value anonymity. Can you speak to that a little bit, and how the firm really can protect the names and other identifying indicia of a whistleblower or a potential whistleblower?
Yes, absolutely. And that's an extremely important point, because, many times people are very, very reluctant to reveal their identity, because they know that if they do, even with the protections that exist, they could suffer damage. And sometimes it's extreme damage in that, people can't work in their chosen business again. I mean, think about that for a moment. You've chosen this particular profession. And then one day, because you had the courage to report something that you saw was wrong, you no longer can work in that business. So one thing the whistleblower program does, and these rules were extremely well thought out when Jordan and his colleagues were drafting them, is one important thing it does is it allows for anonymous reporting. Now, for anonymous reporting, you have to be represented by a lawyer, but it permits anonymous reporting, and that's important because, as I said, people can find themselves in extremely difficult situations. We do tell our clients, though, there are situations where, and this was true as a prosecutor, or as an in-house corporate compliance person, we had an anonymous reporting hotline, as most corporations do. But sometimes the information is so narrow that it telegraphs the identity of the reporter, because people think, well, that information could only come from this person or these 2 or 3 individuals. So we're very careful in counseling our clients about, before you embark on this, these are the risks that are involved. These are the risks that are out there. And part of our job, part of our value added, is to make sure that people understand what it is they're getting into. Because even though the program permits anonymous reporting, and that's valued, there are no absolute guarantees. And especially given some of the information that people have, people kind of piece things together. Now, that's not always true. We've had clients in the practice that have given anonymous information. Ultimately, the commission has to know who it is. The commission does, but the commission is very, very discreet in their handling of information, as is the Department of Justice. But at some point, people may be able to piece things together. But we have had clients, Tom, where, very critical information leading to very large enforcement action, and no one's ever figured out, well, this is the person that provided this information. Of course, if there's an award at the end of the process, sometimes that award is a significant award. And sometimes there are issues related to, how am I going to alter lifestyle choices at the end of the process?
Well, Stephen, unfortunately, we're near the end of our time, but I was wondering if anyone listening to this podcast wanted or needed to contact you via email or check out the firm's website, how would they do so?
The best way to contact us, Tom, is, and we work as a team, and that's the great thing, and that's what attracted me, among other things, to this practice, is we do everything as a team, so our clients get the benefit of our team, whether it's the partners or whether it's the supporting people, the accountants, the former FBI people, the controllers. So the best way to contact us is through our website, and that's at SEC whistleblowerinadvocate.com, or they can just go to the Labaton.com website as well, and that'll direct to the SEC Whistleblower Advocate website.
So I've been visiting today with Steven Durham. He's a partner at Labaton Sucharow, in the firm's Whistleblower Practice. It's been a fascinating discussion of the SEC Whistleblower Office and indeed Steven and the firm's Whistleblower Practice. Steven, I really wanted to thank you again for taking the time to visit with me. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate us, as it would help in our rankings and help get the word out about the most senior podcast around in compliance. Also, if you have any questions, please feel free to email me at tfox@tfoxlaw.com. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report, and I hope you will join me again for another episode.